Mr. Sharifullah, I think you are
Oh,
muted.
okay, sorry. Okay. Good afternoon, everybody, ladies and gentlemen. I hope I find everybody safe and well today. Thank you for joining this session. Okay, I just want to run through earlier what we will be discussing this morning. Let me share this slide first. Sorry. Okay, hope everybody can see this. Okay. Okay, so under this topic, unfair treatment of employees on the grounds of health and sex, I will touch and discuss of course, the issue of security of tenure in Malaysia. Then I will go into what is the definition of workplace discrimination. I also will touch upon what has an NGO calls by NGO in Malaysia to call an end to discrimination at workplace. And fourthly, I will also discuss how employers should deal with employees who are on long-term absence due to illness. Okay. And I also will discuss, introduce and explain the doctrine of frustration of contract in Malaysia, which will relate to the contract of employment, of course. Yeah, I won't discuss the civil aspect of it. I also will discuss code of practice on prevention and management of HIV or AIDS at the workplace, as introduced under the Ministry of Human Resource. And finally, I will to illustrate how's the court's sentiments on dealing with this issue, industrial court decisions on this topic. Right? Without further ado, let's go. Okay. Of course, security of tenure in Malaysia has gained its importance to the extent courts have equated it to what do you call property right, and in this the right of livelihood is one of is seen as one of the fundamental liberties guaranteed in the federal constitution under article 5.1. Okay, therefore this must be translated into practical assurances that no employer can dismiss or even contractually terminate the services of his employees save with just cause and excuse. We'll come later what constitutes just cause and excuse. Yeah. So therefore, in this way, to deprive an employee of this right without just cause and excuse is against the spirit of the federal constitution, yeah, under article 5.1, where dismissal is contemplated. Employers must adhere to the strict requirement of substantive justification of procedural fairness, right? So as I mentioned, the term just cause of excuse, of course, naturally, the burden under Section 20 is on the employer to prove why an employee is dismissed. Right? This is because the rationale behind this, because it is the employer who took the decision to dismiss or terminate or bring the employment to an end. Therefore, it is his duty to state the reason and establish to the satisfaction of the court that he has just cause for dismissing the employee. What constitutes just cause or excuse? It all depends on case by case basis, right? Whether it's fair, in line with the procedures, in line with the code of conduct, and so on, right? Okay. Now, what is workplace discrimination? So generally, it is a prejudicial treatment at the workplace which affects hiring, affects this act, yeah? Hiring, firing, promotions, salary, job assignments, trainings, benefits, and or layoff. And these are motivated on the factors of age, gender, sexual orientation, race, religion, even national origins, disabilities, or health. So it's not based on merit or whatsoever. So these are the factors when these are the factors relied upon or considered, it constitutes workplace discrimination, so unfair discrimination, right? So the Joint Action Group for Gender Equality, JAG, has called to protect job seekers from discrimination under the proposed amendments to the Employment Act. Is according to them, this will benefit thousands of job seekers as well as over 500,000 people who are unemployed in Malaysia, right? So this is crucial given that discrimination often happens during the recruitment process, affecting the employment opportunities of many individuals. So according to the Women's Aid Organization, more than 40%. I must say this is 2019. I haven't got the latest one, but this is as early as I can get. More than 40% of women. So this is a discrimination based on unfair treatment on grounds of sex, right? So women have experienced discrimination on the basis of pregnancy, right? There's even quite a specific case law, which I'll discuss later, right? So JAG also said that the lack of protection for job seekers further marginalizes populations that already marginalized, right? Already there's unequal treatment at the workplace, for example, for women, right? And thus decreasing the quality of life and pushing these groups into even poverty, I must say, right? So even people of different orientations, right? I use quote unquote orientations. You see here, you'll understand as I go on the what's quoted here. Often also face discrimination during the recruitment process, where the study against transgender persons, discrimination against transgender persons in KL and Selangor, the Human Rights Commission of Malaysia, Sohakam, showed 59% of respondents, 49, whom constitutes of 49 trans women, 8 trans men out of 100 respondents, which is 69 trans women and 29 trans men, and 2 intersex persons were denied employment and had their applications rejected. So these were without looking at their merit, whether in terms of their ability, right? So the respondents also shared, some of them also shared intrusive questions, among others, to change their gender expressions, particularly in how they seen outwards, for example, to cut their hair and all that, right? Okay. So this is it has been emphasized how Malaysia has an international obligation to protect job seekers from discrimination, having ratified from the UN Convention on Elimination of All Forms of Discrimination Against Women, CEDAW, and the UN Convention on the Rights of Persons with Disabilities. So this is what caught my attention. These discriminatory practices in hiring process led to gross misallocation of human resources. That means what it states here is that people are not hired according to merit. So it is how they appear and based on sex and orientations and for even nationalities, disabilities and gender and all that, right? Without even looking whether the person in the first place were able to carry out the job function or the job description. So this what it is meant by gross misallocation of human resources. So it's a waste. You're having without looking into merit, you're hiring even incapable people into the job position. So this is in terms of internally would be bad. Now, as the topic suggests, we will discuss on 2 prongs of unfair, how employees should deal with the issue of treatment of employees on grounds of health and sex. Yeah. So let's look at the issue of how employers can deal on dismissals on health grounds. It must be understood, besides misconduct, poor performance, retrenchment, employees are also dismissed based on prolonged illness. They are not in the organization for such a prolonged period, then leading to employees without having the what do you call, having choice but to dismiss them. But these steps must be very sensitively handled. As I've pointed out, this does not involve misconduct. So there's a specific criteria that I will come to in how employers should, when dealing with dismissals on health grounds. Incapacity is recognized by law as a ground to terminate the service of an employee, provided that the illness was such as it interfered materially with the performance of the contract. So, for example, a person is hired as a site engineer, then because of the illness or some incapacity, the person cannot anymore function as a site engineer. So the person is incapacitated simply, to put it simply. So therefore, as I highlighted earlier, alluded earlier, there are certain requirements that the employer must comply before it may proceed to terminate employees on grounds of frustration. So this is a doctrine that I'll explain. Frustration, there's a doctrine called doctrine of frustration of contract. So in most cases where employees, this is general classification. Generally, when an employee suffers from serious illness such as heart attack, stroke. Stroke is very serious. They can't. Some of them can't even recover to the original state. Cancer is a big one, because not many would be able to recover or survive this. And of course, mental disorder is a serious kind of a condition that, again, not all would have the strength to recover and come back to the what they call state where they are able to work as usual. So when employees suffer this kind of serious illness, the law does not demand the employer keep in the employee if there are no signs of recovery. So we all must understand, whatever it is, companies are there for the purpose of profit. So it's not charitable organization. Even employees of charitable organization, if they are unable to function as per how they are hired in the first place, so in the eventually it will be leading to them to be dismissed on grounds of frustration of contract. So let me explain what is frustration on contract. This doctrine in Malaysia occurs when either party to the contract, in most cases, mostly employee, is not able to fulfill his duties or obligation under the contract for reasons which are beyond his control. Why I brought this up? Because it is not him. For example, we speak about misconduct or poor performance. Those are elements within the control of an employee. You can have the intention not to conduct misconduct, or you can you can perform better. It's all under the control and of the employee. But these are sickness and illness, and incapacities beyond the control. It can happen to anybody, right? So most commonly, employers allege frustration when employees are unable to work because of, as I said, serious illness or disability, or detention by state authorities. If an employee suddenly is in prison for a long period, or even short period, few months also, employers can rely on the doctrine of frustration. There are also instances where employers also can be it can affect the employers. It's not only the fault of employees. Maybe suddenly the company no more exists, because of, for example, a situation of war, right? So suddenly the business is destroyed or whatever. These are extreme kind of a situation where it affects the business, and the business is just suddenly the employer can't even perform his part of the contract, right? So those are very very rare kind of situation. The common one is always on the part of employees, serious illness and disabilities. So okay, so this what according to the court said in terms of application of the doctrine of frustration. It said that it cannot be disputed. This is the case of Kumpulan Gatri Abraham, where it cannot be disputed that illness or incapacity which is permanent in nature will frustrate the contract. So will illness which is of so prolonged in nature as to prevent the employer from getting substantially what he has bargained for. This means, like I explained earlier, this is if the employee is hired for a specific reason, for example, a driver, and due to back injuries, he's unable to drive. So it cannot be expected for the person to be maintained in employment in another capacity, because you can't just simply create a position for this employee. But I'll come to where courts have applied, sympathy and all that. Okay. Now this is also concept in light of discussion, the dismissal because of on grounds of health, right? This basically medical boarding out basically mean termination of an employee's services on the ground that the employee has no or little prospect of recovering from a chronic illness or injury. So some people can recover, and some people don't have the prospect, especially some good examples are cancer, strokes. So they physically unable to come back to the original state. So in this case of MHS aviation, where the court has emphasized, this is very important, in justifying, in the industrial court is a court of equity. Of course, it will be fair to both parties. That is why it emphasized there is a crucial balance that needs to be struck between the employer's need for the work to be done and the employer's need for time to be recovered, to be held. That means you cannot just simply, because an employee is sick, you assume his no more will be able to contribute to the productivity of the company. So there must be opportunity given to the employee to recover, right? So if there is definitely no prospect or even little prospect, company can exercise this right of dismissing employees under this ground, right? So this I have laid down the steps. So when an employer faces long-term absence of employees through illness or accident, so the decision to dismiss such an employee must be a reasonable one. In light of the existence of facts pertaining to the medical condition of the employee. So generally, before an employer may invoke the doctrine of frustration, these are the consideration that must be complied. The employee must be consulted by employer on his medical condition. So here where the doctor's recommendation, doctor's assessment, doctor's observation, for example, after surgery, the doctor will assess to physiotherapy, send the person to physiotherapy to recover, to see whether the person is gaining back his ability, or is it a permanent kind of incapacity. So all this must be consulted. Definitely goes without saying. The employer must consult and must ascertain the medical condition, right? So okay, then naturally the employee must be given opportunity to explain why he should be given a chance to remain in employment. Why is this kind of leeway? Is because we must understand it can happen to anybody. It is not because of his own fault. Remember, we have emphasized the issue of beyond his control. So that is why on the third point, courts have emphasized employers must approach this situation on sympathy, understanding, and compassion. So because of the because of there's non-existence of element of wrongdoing on the part of the employee. So sympathy, understanding, and compassion must be there, right? So fourthly, the employer must allow the employee to remain in employment for a reasonable time of period. You cannot just straight away dismiss the person, so that the employee is given an opportunity to show improvement on his medical condition. Of course, employers also sometimes they assist them, for as I highlighted earlier, to send them to physiotherapy to gain the strength, follow-up treatments. For sometimes for mental illness, there are sessions where with the psychiatrists and all that, so that they go through that process to come to recover, right? And finally, the decision to dismiss must be in final, the initial medical condition, of course, consultation with the doctors, and finally, it must be supported by a substantive medical report, substantive medical evidence, which finally says that despite the follow-up treatments, despite the ongoing medications, despite, for example, physiotherapy, all kind of therapy, unfortunately, there's no prospect, and there are little prospect. So this is what I mean by sufficient medical evidence before an employer can proceed to dismiss, right? So this it's not as easy as some other type of dismissal. It's very stringent, and courts are very sympathy to the condition of the employees. Okay, so the relevant consideration that one would examine in deciding whether an employee should be terminated on grounds of absence to illness, ill health, nature of the illness. Okay, as the time as I described earlier, the likely length of his continued absence, and the urgent need for employer to execute the work and of which the employee was engaged for. Engaged for him. So these are basically the factors that will be relied upon for management to take decisions, right? You cannot just simply while giving them time, it cannot be, there must be a reasonable time. You cannot, because at the same time your employees are left in a limbo where you don't know when they're coming, and the workload is now being shared by the co-workers. That also can be disruptive to the daily operations. At the same time, you also stopped from finding another employee to replace this employee. So that's why the length of this absence must be reasonable. How reasonable it is dependent on the company's, each of the organization's operations to justify this. So it varies to case and varies to organization in terms of types of the function, right? Some functions can be extended, but certain function cannot, right? So that's why there's a balance and all that. Okay, and I must also touch in terms of when we are discussing about unfair treatment of employees on grounds of health. This is very relevant. This code of practice of prevention and management of HIV and AIDS at the workplace is provided by the Department of Occupational Safety and Health, OSHA. Under the Ministry of Human Resources, under this department, under this ministry. So the purpose of this code is to reduce the spread of HIV or AIDS, and to provide employers and employees in managing issues relating to HIV or AIDS at the workplace. So I will highlight this clause where it is propagated to employers to be under this clause 3.3.4 to be non-judgmental, non-discriminatory to employment practice. So this is what being propagated to employers, where employment practices should be based on scientific and epidemiological evidence that people with HIV or AIDS do not pose the risk of transmission of the virus to co-workers to ordinary workplace contact. So this kind of awareness should be in the organization. And just because a person and also HIV positive status should not be the sole criterion for disqualification or any form of employment. So it should not be discriminated on this point. And also such an employee should have the right to continue as employment so long they are able to work, as long they do not pose any danger to themselves, their co-workers, and any individuals of the in the workplace. Then the procedure for termination on medical ground should be the same for such an employee for any other employees of any other disease. And finally, disciplinary action should be taken against any employee who discriminates or stigmatizes HIV positive or perceived HIV positive employees. And also clause 3.3.5 also emphasizes where an employer should ensure that the HIV positive employees is not required to disclose his or her status to the employer or anyone at work in this situation where employee needs to reveal his status confidentially regarding all medical information relating to HIV status should be maintained at all times. So this is what I wanted to point out under this code of practice. Okay, now it's important for us to we'll go through some of the cases which can illustrate industrial courts, illustrate the issue in hand. So, for example, in the case of Compass Oil, where the claimant was diagnosed with sleep anxiety disorder, and despite undergoing medical treatment, the claimant's condition continues to deteriorate. This is, although going through treatment, unfortunately, it's not improving. So that is why the court, it was held by the chairperson that since the employee was unable to perform his duty any longer, because it's not improving, so therefore, in view of this, the employment contract has become frustrated. So gone through the treatment. Secondly, despite that, there's no improvement. So the court has felt this is just. Okay. This case also involving a knee pain involved by this case of Gledhill, Malaysia, Berhad, where it is stated that there had not been any medical opinion to state that the claimant would ever recover. Okay, so there's no conclusive medical evidence to support the claimant's averment that he can recover, right? So the numerous number, the court took into consideration the number of days of medical leave taken by the claimant, as well as the medical evidence in conjunction of his injury, which led to a gloomy picture of his condition. So if the claimant were to continue with the company, it was foreseeable he would take many more medical leave, which would inevitably affect the productivity and profit of the company. So that is why earlier I say that there must be a balance, and a balance of company to run its operation for the purpose of profit. And on the other hand, it must balance also the reasonable treatment of employees who are in the midst of recovering from injuries. So the Court of Equity under Section 30 of the Industrial Relations Act, based on equity, good conscience, and the substantial merit of the case, which apply equally both to the company and the claim employer, employee. It's not on one-sided only. It was found that the claimant's termination was indeed carried out with just cause and excuse, and the supervening event had been the the court even went on to see what was the reason, and this is outside the work injury, a football game injury, which had eventually frustrated the contract, right? So from this why probably we can assume that court probably will be more we can not assume, there are some cases where courts are more sympathetic where when the injury happens in the course of work, but in this case the injury because of some football from personal involvement in the football game, so the court felt that the company could no longer wait. Okay, this is an example of mental illness in the case of University Malaya, where employee suffering from paranoid schizophrenia was unlawfully dismissed. Okay, the earlier case held that there was a lawful dismissal. So this is an example of unlawful dismissal, where this is because when the employee had not fully recovered from her illness at the material time of the period of the absence of the work complaint, and also at the time of the disciplinary hearing, the DC had not been given by the management a copy of the medical report. So what happened in this case clearly is, among others, the deliberation by the decision-making body was not supported by the medical opinion or medical report. So this shows that in taking decision in this kind of situation, it must be well supported. It cannot just because you need an experts. For example, in this case, is a medical certified medical doctor, doctor practitioner's certification, but unfortunately, that was not considered by the decision-making body in University Malaya, right? Okay, so and also in this case, in an English case of Paragon Wallpapers, this is a principle highlighted. So every case depends on its circumstances. The basic question which has to be determined in every case is whether in all the circumstances the employer can be expected to wait any longer, and if so, how much longer. The court added that the nature of the relevant circumstances involved, nature of the illness, likely length, as I highlighted earlier, the need for the employer to have the work done, the work done which the employee was engaged to do, right? And further, the courts have emphasized, this is very important. This is an example in the Sime Darby's plantation case, where this is to highlight the consideration by the industrial court, being the court of equity, where according to the court, in case of dismissal for sickness or partial disability, where contract or employment had admittedly not ceased to subsist to frustration, the burden of proving the justness of the dismissal lies with the employer. So in determining this issue, the court take into consideration the size and administrative resource. This is interesting. So if the court thinks that the company can afford to give the employee more time to recover by virtue of its size and administrative resource, that ought to be taken into consideration. This is so. That is why I mentioned it goes according to organization and based on each operations. And went on in this case. Also, the court also took into account the employer's obligation of social conscience. We all must remember the Industrial Relations Act is a social legislation. That is why words like court of equity, social conscience, all comes into picture. So in order to assist the workman, his employer, by minor adjustment. Okay, there are some type of cases where the court have emphasized if the employee could not perform this function, maybe a lesser function could be allocated in order in all important right for livelihood. Maybe certain companies could consider, but again, it depends on the company's resources and size. And these adjustments are such as transfer, creation of special job for the sick employee on a lower pay where circumstances permit. Not every organization are able to do this. So the courts are of the view that these are not unreasonable consideration, bearing in mind that nowadays many modern and socially conscientious employers go out of the way to give employment to handicapped persons. Sometimes I've seen in the courts, they are blind telephone operators. So these are the type of adjustments that organizations can adopt. So we have earlier talked about how employers should handle cases involving issues of health. Now, this is a subtopic under the how employers have been dealing issues of treatment of employees on grounds of sex, right? So the usual common ones are when employers use pregnancy as ground for termination of an employment. Where I will illustrate few cases. This is a case of Nur Fadila Ahmad Saikin, where during the her interview with the Hulu Langat District Education Office, during the interview, she was never asked about whether she's pregnant or not, right? And no employee, if not asked, nobody would want to just simply announce to anybody that they are pregnant or not, right? So upon this employee, this is after the interview and being selected. So upon reporting for duty, she was dismissed by the Ministry of Education on the ground she was pregnant. The ministry was of the view she is not suitable for the position, right? On this ground, right? So this is where clear discrimination. So once she did aggrieved by this decision, she applied to the High Court for declaration that the Ministry of Education's decision was unconstitutional. I stopped here. Remember earlier how I equated the right for livelihood has been seen by courts of law as similar, the right to property under Article 5.1. Yeah? So the High Court held that the discrimination on basis of pregnancy is indeed a form of gender discrimination, where the Ministry of Education, especially being a public authority, acted in conflict with the Constitution when it sorry, the spelling here, so apologies, when it discriminated against the teacher, right? Okay. I will. The next set of cases will usually what I've noticed are in the context in the airline industry. Yeah, for example, in this case of Prasanna Kumari Govi, the claimant came back for duty upon her first confinement, and she was her weight was over 61 kg, and the court finds that the claimant was treated badly by the company. So usually stewardess, they have it is agreed they cannot go beyond a certain weight. So the court have looked into the collective agreement, Article 25(2), which required the company to hold due inquiry, and this was not done by the company. Company, in fact, relied on the grooming rules in place of the collective agreement. You must go back to the what's agreed between the employer and employees. So this is the collective agreement between the union and the company. However, rather than looking at that, the Malaysia Airlines looked at the grooming rules only. So taking equity, the court was of the view the termination was without just cause and excuse. Okay, these two cases, Beatrice Fernandez and Audra Denise Atkinson, also against Sistem Penerbangan Malaysia. In both cases, the employees became pregnant with their third child in direct contravention of Article 27 and J of the collective agreement. Okay, the difference in this case and the earlier case is earlier case did not consider the provisions of the collective agreement, right? But this case, clearly there was consideration where it was found that they are in direct contravention, which states that a female cabin crew when they become who becomes pregnant with her third child after having two surviving children shall resign from the company, failing which the company may terminate her services. This is what agreed terms with the company and employees. So unlike the earlier case, in these two cases the court held in favor of the company by stating that the clear contravention of Article 27J, that the company did not possess any suitable ground position at that time. Therefore, the terminations were with just cause and excuse. Okay. Also, again, still we are in the airline industry. The case of Yao Pao Ching, where the claimant was given study leave for 18 months, where she became pregnant and gave birth to her child. So this is what the court held. In application of the law in regards to the valuation occasioned by the supervening period of approved leave, the equitable doctrine of forbearance operating as an extorter, the fundamentals of contractual requirements not included, and based on the reasonable test applied to the strict construction of terminology in clause 2.3, Article 6 of the collective agreement, it was a finding of the court that the termination of the claimant of a summary nature to be unreasonable and unduly harsh. Must give them explanation to explain. Opportunity in view of rules of natural justice to explain their position, having regard to the constitutional position that the right to livelihood was equated to the proprietary right of individual. So why all these are important? Because these four exposures to employers, where if the court finds the dismissal is without just cause or excuse, the court may order reinstatement, compensation, or compensation in lieu of reinstatement, back wages, and in some rare cases where the court finds that the victimization is very serious, even punitive compensation. Yeah. So with that, I come to conclusion of my talk today. Is it okay? Can I see any questions anybody have today?
Is there any question from the floor? If there is no question,
either everybody very hungry during Ramadan, can't wait to go on, or my presentation is extremely clear today.
Actually, it's extremely clear, Mr. Sharifullah. So,
okay.
On behalf of our law, thank you for joining us. However, before leaving, we appreciate if you can let us know your feedback. Our next webinar will be on 20th of May. You can email or WhatsApp me anytime to get the details. Until then, thank you and goodbye, and Selamat Hari Raya.
Thank you, everybody. Selamat Hari Raya.
Thank you, Mr. Sharifullah.
Hari Raya, thank you.
Selamat Raya, thank you.
Ayo. Selamat Hari Raya.
Okay, Vishnu, do you want to continue?
Okay, hi. Okay, I'm here. This is Vishnu.
Okay, Vishnu, you can continue.
Okay, just a sec. I'm just trying to finish off this vote. Okay, I skipped the poll. Okay, so hello everybody. Who's here right now? Let me take a look at the participants. Hello, can you hear me? Umi?
Yes.
So
Yep, we
who's
can hear you.
staying behind for some question and answer session?
Sorry, your question again, Vishnu?
Well, you're mentioning that there will be some of them who will be staying back for some question and answer session. Who is that? Is it the list of participants we have here?
Yes, these are participants we have here.
Okay. Hello, how do you do? My name is Vishnu. I'm the consultant with IR Law. We'd like to thank our associate lawyer in charge, Sharifullah, who was gracious enough to spend some time with us on a very interesting topic. So much so, you're so clear that I have no questions whatsoever. Thank you, sir, very much.
You're most welcome.
Hope you have a good buka puasa later on.
Thank you.
I hope to see you again as well.
Yep, no, pleasure will be mine.
All right. Thank you so much. So as for the others, those who are still here who wish to pose some questions on some IR issues and so on, as I mentioned, I'm Vishnu. I'm the consultant for IR Law. And what we do is we have a membership scheme for companies, member companies to join us and subscribe to our services. One of it being our webinar sessions, which we host and co-host with some of our associate lawyers who we know very well. They've attended conferences with us as well. And secondly, what we do is we provide IR services on the latest IR issues. We also provide updates, and we also try to resolve some of the some issues, pending issues, IR issues and labor issues that our member companies are experiencing. But what we do is we provide our IR services as such. And aside from